third document that we prepare in a simple estate plan is called a Health Directive, or a living will. And that's received a lot of publicity lately, because what that does, a person appoints a power of attorney or an agent to act on their behalf for medical issues or living issues if in fact they're no longer able to make those decisions. Typical example would be, parents or grandparents have dementia or become incapacitated for some reason, and another family member needs to check them into a nursing home or receive medical treatment or come up with a plan for prescription drugs, those types of decisions. In Minnesota, like with the financial power of attorney, a healthcare directive is a fairly simple check the blanks form. It's meant to be filled out for people to be able to do it by themselves. And essentially the form does two things. First of all, it appoints a person to act on behalf of the principal. You'll name someone, one of your children or your spouse or a relative, to be able to make healthcare decisions for you when you're no longer able to make them yourself. The second thing that a healthcare directive does, it gives you an opportunity to essentially write directions or instructions to that attorney, in fact, or other people about how you would like to have your affairs administered. For example, you can indicate whether or not you want to do organ donation. You can indicate whether or not you want your remains to be cremated or buried. You can indicate instructions on health care, whether or not you want to be fed intravenously, whether or not you want to receive pain-killing drugs if, for example, it might impair your ability to be lucid and conscious. And those are the type of things that people look at, and those are the instructions that can be set out in a healthcare directive.